Dear students, JPS CLAT Academy at Gyanodaya, a senior secondary school at Sikar, supports its students in their CLAT preparation. We have started a lecture series which will be delivered to you on a daily basis on YouTube. The lecture series revolves around discussion of mock papers. You can request us for the concerned mock papers. If you intend to join us in our daily discussions, you are most welcome.
What do you have to say on this? That Article 21 has been subject of interpretation through the doctrine of constitutional silence. Yes, you can say that. Why? You can say so because you see nowhere in Article 21 it is mentioned that you shall have the right to clean air, you shall have the right to livelihood. Livelihood, you can say right to life, all right, but then it is nowhere stated that you will have a right to speedy trial. This is not mentioned there, right? So there are so many things which are not mentioned there, but the courts have implied all that into, they have read all that into Article 21. In fact, the courts say that anything that makes life better, then that is included in Article 21. So what is that? Constitutional silence. The content of Article 21 is silent, but then the silence is being used by the courts in a creative way to enrich the scope and to make it more dynamic, and in a way that the Constitution grows an organic document. All right. So in this case, there are two aspects of the the doctrine of constitutional silence. One is in the case of the speaker and another is in the case of the governor. The speaker, basically, there is nothing specified in the 10th schedule or elsewhere that the speaker will take so much time in deciding the petition, disqualification petitions in regard to MLAs who have joined some political party other than their parent political party after their victory in the elections on the ticket of the original party or their parent party. So, and then second is of course the governor, the pocket veto being exercised by the governors in not granting assent to bills forwarded by the state legislature. So in both cases, both the high constitutional functionaries, the gubernatorial post and the speaker's post, both are high constitutional functionaries. Both of them have taken advantage of the constitutional silence and delayed taking decisions on the bills on partisan lines. Now, in this context, I will recall here the report of the Sarkaria Commission on the center-state relations. The Sarkaria Commission had described the role of a governor as that of a friend, philosopher, and mentor or guide. But now the present role of the governor has been more of an obstructionist kind of, it is just an extension of the party politics and not the constitutional role as envisaged in the Constitution and as elaborated by the Sarkaria Commission. That is not the way in which some of the governors at least function. So this article sets a timeline to the speaker as well as to the governor that 3 months or 90 days time you have. You can sit on the bills only for 90 days or only for 3 months, not beyond that. If you go beyond that, then it would be a subject of judicial review and appropriate directions would be passed thereat. Now, why so much hue and cry is being made over the exercise of pocket veto by the governor and the speaker? The reason is that we have a prime ministerial form of government. In the prime ministerial form of government, and the another form of government is the presidential form of government. In the presidential form of government, there is a clear separation of powers. But in the prime ministerial form of government, there is an overlap. We have a prime ministerial form of government in the center also and in the states also. The same model is being replicated at both places. And in the prime ministerial form of government, it is the will of the people which is vested in the lower house of the parliament or in the state legislative assembly, the Vidhan Sabha. Now, if a governor who is a central government nominee comes and sits upon the will as expressed by the people through their representatives, elected representatives, then it is a subversion of the constitutional process. That is the reasoning based on which they are saying that the governor cannot do like this. Likewise, the speaker, when the constitution says that you cannot change the political parties after your election, then in that case, once again, you are setting to naught the constitutional principles enshrined in the 10th schedule uh, by indefinitely delaying and taking a decision on the disqualification petition. Then it is a subversion of the constitutional scheme. The speaker comes from the ruling party, so one can understand the political partisanship that can come into play. Likewise, the governor also belongs to the ruling party at the center because he is the central nominee. Therefore, there can be a conflict of interest. But then the constitutionalism requires that the high functionaries should not act merely on political lines, but they should act on constitutional lines. They should act the way the constitution wants them to act. It's interesting that the scope of judicial review in this regard is very limited. The scope of judicial review would not extend to the Supreme Court giving any guidelines to the governor or to the speaker as to the manner in which they have to exercise their option. They may decide rightly or wrongly, but they have to decide, they have to take a decision within a reasonable frame of time. The Supreme Court may later on exercise of judicial review, declare upon whether their exercise of power was lawful, whether it was within the confines of the Constitution or it was for extraneous considerations. That is, they can review the procedure by which they took the decision. But on the merits of it, the courts would not substitute their opinion for the opinion of the governor or for that matter the opinion of the speaker. If two views are possible on the same subject, the Supreme Court would rather go by the view of the governor. But if the view is perverse, then the Supreme Court will strike it down using its power of judicial review. If two views are possible and it is possible that the governor could have acted in a particular manner, and it is also possible that the speaker could have acted in a particular manner, the Supreme Court is not likely to interfere with that. But if the view taken by the governor or view taken by the speaker is absolutely perverse, completely disowns or derogates from the constitutional scheme, then in that case, the procedure by which they have arrived at the decision would be a faulty procedure, and the procedure would be struck down. Though on the merits of the case, the Supreme Court would not say anything, but the end result may be the same. The end result may be the same, that the erroneous decision may be struck down. This is in the year 2024, state of Vedanadu. Governor did not act upon 5 bills. Here, what you have to emphasize is that this is 2024, and whereas the ruling of the Supreme Court, I think, has come in 2025. Therefore, whenever there is a date, please be careful, because most of the judgments are prospective in their operation. They are not retrospective. They don't apply from a back date. They apply from a forward date, means from the date of the decision. And since that is a 2025 decision of the apex courts, probably of April, and this year is set to be 2024. Therefore, at that time, that ruling of Supreme Court was not available. And since the ruling was not available, the Supreme Court will, your choice will be as the law stood at that time, not as the law has stood today, as it has been declared today. 2024, in the state of Vedanadu, the governor did not act upon 5 bills. The bills include public welfare schemes. The state government accuses the governor of acting on political motives. Shortly thereafter, the state government decides to initiate action against the governor for inaction and move the apex court, which issues directions within a fortnight of the petition. What would be the likely outcome of the case? Supreme Court may initiate action against the governor. That is unlikely because of the doctrine of separation of powers. He belongs to the executive. Supreme Court belongs to the judicial wing of the government. They would not like to take an action against a parallel constitutional authority. Supreme Court may direct the bill. Yes, this is possible. They may direct the bill as duly passed. Governor can be removed for political vice. This is not the job of Supreme Court. Courts cannot intervene in international functioning of the governor's office. This is correct that courts won't function, but then they are not beyond the scope of judicial review. If the functioning becomes perverse, then definitely the courts can look into it. Supreme Court issues a direction to obey timelines indicated. Issues a direction to obey timelines as indicated. At that time, there were no timelines actually. 2024 timelines have come only recently, right? Mm, this decision is of actually April 2025, and the passage has been set into the time frame of 2024 intentionally so as to test your analytical skills, right? As to where it applies, where it does not apply. Next question 78 is fully correct. The next is also fully correct. Next is also fully correct. Next is also fully correct. Please come to the next fact situation, the passage 17, logical legal reasoning. Yes. These questions may be framed on current legal awareness also out of this, because this is based on 2025 decision, April 2025 decision of the Apex Court. These are very, very hot topics. So it's possible that a question may be framed also in the current legal affairs portion.
Passage talks about the Chhattisgarh High Court rule against the state government attempt to recover 9.23 lakh from the pension of the Rajkumar Goenka, retired government officer. And court the court found that the recovery lacked legal basis as Goenka was never found guilty in any judicial or departmental inquiry. So rule number 9. Rule 9 of the Chhattisgarh Civil Service Pension Rule 1976, the pension can be withheld only if a retired employee is found guilty of a grave misconduct or negligence in a proper proceeding. Such no finding existed, the court ruled the recovery was invalid, and under the Article 300A of the Indian Constitution, protect the property right, meaning the government cannot take away any pension or gratuity without following the legal procedure, and the court held the pension and gratuity as a hard-earned benefit and cannot be deducted arbitrarily. And the judgment referred to earlier Supreme Court decision, which emphasized the need for fair hearing before taking away pension benefits. And despite the Goenka denial of allegation, the state ordered pension recovery and claiming to do the process follow, and the court quashed the recovery order, stating that the pension deduction cannot be made without legal backing, and the state government was directed to return the deducted amount to Goenka's legal hire within the 45 days.
This article is about the doctrine of due process, I believe. So here we have a Rajkumar Goenka, who was a retired deputy director. Now, he was accused of misappropriation during his service. However, there was no departmental inquiry that found him guilty. But however, the state government had anyway ordered the recovery of a large sum from his pension. So this matter had then went to court, where the High Court had in its verdict squashed this order, squashed this recovery order, saying that the recovery order was illegal and not supported by law, and that he should be directed as a refund within 45 days. So the finding that was in this case was that pension and gratuity of a person is effectively their property, and that they should not be deprived of the property in a arbitrary fashion, and that there should be a due process, and that he was not found guilty since there was no due process.
So this passage says that the
Rajkumar Goenkar, who is a retired deputy director. He faced pension recovery of rupees 9.23 lakh by the Chhattisgarh government over alleged misappropriation during service, and he denied these charges before and after retirement, and responded to a showcase notice in 2019. And despite no finding of guilt in any judicial or departmental inquiry, the state ordered the recovery, claiming due process, and the Chhattisgarh High Court ruled that such reductions from pension or gratuity can't be made without legal basis, and it cited Rule 9 of the Chhattisgarh Civil Services Pension Rules 1976, which allows such action only if the employee is found guilty in proper proceedings. And the court also referenced earlier Supreme Court rulings requiring fair hearings, and Justice Bibu Datta Guru stated that the pension, gratuity, and earned leave are not bounties but hard-earned benefits, and they are treated as property under Article 300A of the Constitution. And the court held that the administrative instructions can't justify deductions without statutory backing, and ordered the deducted amount to be returned to Goenka's legal years within 45 days. That's all from my side.
Yes.
Sir, I'm not sure how to answer this.
All right, no problem. What happens here is this article is being discussed. The facts are already well known to you that there is this employee who has been accused of misappropriation of property. Government property has put in his pocket and walked away. This is what the department says. And the department has sought recovery of some of nearly 10 lakh rupees from the as being misappropriated funds. And the court lays down a few propositions. Number one is that you should have statutory rules to make deductions. And what is the difference between statutory rules and administrative instructions? Administrative instructions are passed in the form of a circular, or in the in the form of a notification, or in the form of a policy, internal policy of the government, the policy directions to the officers. These are all in the matter of administrative instructions, right? And what is the rule? Rule is it may be a statutory rule, that is, it is provided in the Act, or it may be a constitutional rule, that is, it may be provided in the Constitution, or it may be a rule of delegated legislation. It is provided in the rules made by the usually made by the bureaucracy and approved by the legislative authority, legislature. So this is basically the classification. Two kinds of classification. One is administrative instructions. Administrative instructions are internal departmental instructions which are issued to the officers and which are binding on the officers. If the officers don't comply with those internal departmental officers, internal departmental directions, they can be held responsible or accountable, and they can be visited with consequences. But court says this is not a matter of administrative fiat, the administrative directions. It is a matter which requires a rule-based response. Rule-based response would be like the statute should clearly provide that those employees who are proved to be guilty of misappropriation from their gratuity or from their EPF or from any other scheme to which they might have subscribed, some government scheme, from those we can deduct the payments for the amounts misappropriated. There should be a clear rule that has been laid down in advance If that kind of rule is not forthcoming, then we are not going to hold the employee accountable. Is that clear to you? The difference between administrative fiat or administrative direction and a rule, whether a statutory rule or a constitutional rule or a rule of delegated legislation rule made by the government, whichever. But there must be a rule, and that rule must be in advance. That must be there. Another aspect which the Supreme Court touches upon is of Article 300A of the Constitution. I'm sharing the screen. No person shall be deprived of his property save by authority of law. So, save by authority of law. That means there must be a law, something that you call a law. What is a law? What do you call a law? What is a law? Can somebody take a guess on what exactly would be a law? Can somebody take a guess on what would be a law? Can you do that?
A rule that is created and enforced by some authority, such as the state, that's a law.
Yes. So, law, this is defined in Article 13 in the context of fundamental right, in the context of imposing limitation on the government from acting in derogation of the fundamental rights of the people. Law includes any ordinance. What is an ordinance? Passed when the parliament is not in session. Right? That is an ordinance. Or the state legislature is not in session, and there is an emergent situation which requires a legislative response. So you pass an ordinance. All right. Suppose the lawmaking is the function of the legislature, Lok Sabha, Rajya Sabha. They are not in session. Then how law will be made? And there is an urgent requirement of a law, right? Say COVID-19 is there, and we have to pass a law. How you will pass a law? The parliament is not in session. Either you call the parliament in session, or if that is not possible, then in that case you have to pass an ordinance. Government brings out an ordinance. President promulgates an ordinance. After the House reassembles, this ordinance is tested and either approved by the House, or if the House does not take it up for discussion within a particular period of time, then it lapses. That is an ordinance. Administrative power of lawmaking. Order, bylaw, right? Rule, regulation. What is the difference between rule and regulation? Rule is usually made by government, whereas when the authority, that is in delegated legislation, passes this, then it is a regulation usually. When the authority passes, authority means the administrative authority which has been entrusted the task of implementing the law. And rule means the government. Government makes a rule, then that is a rule. Notification, with something that is notified in the Gazette. Custom is also a rule. If custom meets the requirements of uniformity, certainty, public policy, of being sufficiently ancient, of uniformly being followed, certain 4-5 conditions are there. If those are being met, then custom can also be a rule. Usage, custom and usage, having force in the territory of law. All right. So law is very expensively defined. Therefore, what Article 13 requires is that what Article 300A requires is that it must be passed by authority of law. And you will notice that among the law, the administrative instructions are not there. Here, ordinance is there, order is there, bylaw is there, rule is there, regulation is there, but administrative instructions are not listed there. Why administrative instructions are not listed? Because the Constitution wants that some things must be reserved for the law. What is the difference between law and administrative instruction? The law cannot be altered at your whims and fancies. It is the black letter of law. Whereas administrative policies, today they are there, tomorrow they are not there. Administrative policies can be arbitrary, though the rules can also be arbitrary. No doubt about it. But administrative instructions, what is there today, they are there. Tomorrow you just rub it off, and this is the new administrative instruction. There is a rule, law, the ordinance. All these are not like that. All these are crystallized. All these are crystallized by a particular process, and thereafter they come into force. It is not like administrative instructions when standing at a particular place, a person says, do this. That becomes an administrative instruction, right? Internally, he directs the officers to take certain actions and the matter comes to an end. That kind of thing becomes. Now, everything is not a matter of administrative instruction. Why? Everything is a matter of administrative instruction. Then there will be a chaos. Then the bureaucrats and the politicians, they will just set aside everything else and make everything a matter of policy and everything a matter of just their instructions. But that is not how it works. There are certain things which are beyond their pale. For example, whatever is crystallized in the law, that is beyond their pale. For example, 10th schedule of the Constitution is there. Why do you need a 10th schedule of the Constitution? When the political class realized, when they realize that, look, this is a problem that has come into existence. So when the problem has come into existence, they will specify the law for it. Because when the law is made, then the authority is there. Authority is there means those authorities' decisions will be binding. They will be binding on everyone, including the political class. Is that clear to you? Suppose the FRBM Act is there. Fiscal Responsibility Budget Management Act is there. Government finds it very difficult to, to resist the political pressure, and they all the time they give in to demands for subsidies, demands for freebies, demands for demands of people, try to meet economic demands of the people, and in the process they open up the government's exchequer, the government treasury, for meeting political demands. Now the government finds it very difficult to resist the temptation because the elections are around the corner in one part of the country or in another part of the country, and they find it very, very difficult to manage. So what they will do? They will make a law on it. Once they make a law on it, then the bureaucratic machinery, then the judiciary, the other wings of the government, they become empowered. They become empowered to act in a particular circumstances in accordance with the law. And even the political class has to obey the law laid down by the parliament. So this passes beyond politics thereafter. So this is one such instance where the court says this is beyond politics. It is not that you can just by administrative instructions deprive someone of his property. You have to pass a law on the point. Law on the point means it binds as much the politician as it does the bureaucrat, as it does the ordinary citizen of the country. It becomes a very, very binding kind of thing, and nobody can resile from it, whoever he may be, whatever may be his stature. So it becomes binding on everyone. The authority that seeks to restrain the employee, the authority is as much bound by it as the employee himself. So that is the distinction between an administrative law, administrative instruction, and a rule. A rule has a binding force. An administrative instruction has a binding force within the department. On the hierarchy of the officers, it will bind, but it may not have any binding force vis-a-vis the rest of the people, vis-a-vis the general population or general what we call as outside the official hierarchy. It may not have a binding effect. It will have binding effect only within the administrative hierarchy, but it may not have any binding effect outside the administrative hierarchy, because people have their rights. People have rights conferred on them by statutes, by rights conferred on them by delegated legislation, rights, constitutional rights, the supreme rights, or all other rights which trump all other rights which are to the contrary, right? So this is one such instance where no person shall be deprived of his property save by authority of law. So you will require a legal authority. A mere dictate by the superior officer or by the disciplinary authority is not sufficient. It requires a law on the point. It requires a statutory or a rule or a regulation. That printed law is required, and a mere administrative instruction without any printed law will not be implemented. and more so when you are denying an employee his hard-earned money, hard-earned money by way of his entitlement to gratuity or by way of his entitlement to provident fund and by way of his other entitlements, for example, medical facilities and all that. You can't deprive a person of his property because Article 300 says that person shall not be deprived of property save by authority of law. So the law must be in existence. An administrative instruction is not the law. The administrative instruction is binding, of course, within the administrative hierarchy. But outside, if you want to implement it on others, then you will require the authority of law. This is what the article, in a sense, talks about. So the article brings out the distinction between administrative instructions and law, the concept of law as laid down by the legislature or under the authority of legislature, right? Is that clear to you?
Yes, sir.
Let's now see the questions. This is 17. Question number 82. I think there are no wrong answers in this. No, there is one wrong answer. 84. Yeah. The tourism department issued a notification deducting leave encashment of all retiring staff as a cost-cutting measure. Is this action constitutionally valid? No. This will be constitutionally valid if it comes as a part of law. It must be statutorily sanctioned. Means either it must be provided in the statute, or it must be provided under the rules made under the statute, or the regulations made under the statute, or some notification that has been taken out and published in the Gazette by whatever name called, but it is published in the Gazette and it is made by the authority, whatever you call it, right? So it will become a law only these requirements are met. If it is only an administrative fiat or administrative direction for cost cutting, then it may not be sufficient because Article 300A says that nobody shall be deprived of his property without save by authority of law. So you'll have to show the authority of law before you take this kind of cost cutting measures. You can surely take them. They are not saying no, but first make out your policy. First publish that policy in the Gazette. You follow the procedures, put it before the state government, you put it before the legislature, whether it is Vidhan Sabha or if it is central government, then the parliament. Follow those procedures and publish it and lay it on the table of the house and let it be debated and discussed. Even if it is not debated and discussed, but it is passed by the parliament, that will be sufficient. But you will have to follow those procedures. Those procedures have certain safeguards. Those procedures prevent the law, prevent the rules from being arbitrary. Because when you put something in the open, they say that when there is a canker of secrecy, then it starts spoiling everything. But if we have everything in the open, then openness or sunshine is the best antidote to evil practices or malpractices. So you have an open system, then in that case, the chances are that justice, equity, liberty, fraternity, all those goals of Constitution as enshrined in our Constitution have a better chance to survive, better chance to be implemented, right? Then this is also incorrect. Health Department issued an office memorandum stating that employees involved in pending vigilance inquiries would have 25% of their pension withheld. There is no provision under the service rules. The moment there is no provision in the service rules for such action, then in that case, even if you have a pending vigilance inquiry, they would not be able to make the deduction. Even if they have come to a finding of somebody's guilt in the vigilance inquiry, but there is no backing in the rules, then too they will not be able to do it. So you require both of them. Number one is that you should be found concerned, or you should be found to be indulging in grave misconduct, regarding financial propriety, or secondly, simultaneously. Secondly, you should have the authority in law, which by reference to which either a rule or a regulation or a bylaw or a notification or something there must be there, something which is published in the official gazette, something which is laid before the legislature. If it is a matter of state government Vidhan Sabha, and if it is a matter of central government, then in that case Parliament. Something must some if it is in the form of rules or regulations, those rules and regulations must be laid on the table of the house, whichever house it is, depending on whether it is state government involved or whether it is the central government involved. So those procedures will be required before taking such steps, and those procedures may also be challenged on the grounds of Article 14, 14, 19, 21 and all. Right. Then 86 is correct, no problem. Then please come on 18, legal reasoning. Yes, quickly go through it and tell me.
This passage talks about the Supreme Court judgment addressed the constitutional silence regarding the governor rule in clearing bill and the president power under the Article 143. And the ruling set time frame for the governor and the president act to end bill and emphasize the importance of judicial review in the cases of perceived unconstitutionality. And the Supreme Court ruled that governor must act within the specific time frame when deciding the bill sent for assent. And the Supreme Court stated that the president ought to seek its opinion when a governor reserve a bill on the ground of unconstitutionality. And the Supreme Court emphasized that the Constitutional Court can assess a bill validity before enactment and preventing the unconstitutional law from being passed. And the judgment said the judgment cited the Sri Lanka Article 154H and Vibhat Section 66, where President must refer potentially unconstitutional bill to the Supreme Court. And Sarkarian and the Unchi Commission, both commission has recommended that the President seek the Supreme Court opinion under Article 143 for bill suspected to the unconstitutional. And the Supreme Court clarified that it cannot rule on purely political or policy related to the matter aligning with the doctrine of political. And it strengthens the judicial oversight in the legislative process and also prevent the unconstitutional bill from becoming law.
So this article is about the primarily about the doctrine of judicial review. So if the governor of a state reserves a bill on it being unconstitutional, then the president is required to seek the Supreme Court's opinion about regarding the constitutionality of the bill under the doctrine of judicial review.
Yes.
So the president and governor cannot decide whether the bill is constitutional themselves, and so the courts will decide if it is.
Yes.
And the court can only give advisory opinions on whether its legality is legality matches the constitutional values or not. If anything regarding if it's anything regarding politics or economic matters, economic policy, then it won't give its opinion since it does not need to involve itself in political affairs.
Yes.
And that since no similar mechanism exists at the state level, the president's referral to the Supreme Court is crucial. The ruling also highlighted this.
This article talks about the judgment on April 8, 2025 of the Supreme Court, where the Supreme Court said that if a governor reserves a bill for the president's consideration due to concerns about its constitutionality, and then the president is ought to seek the Supreme Court's opinion under Article 143 of the Constitution. And Article 143 allows the president to ask the Supreme Court for advice on important legal or factual questions. And while it is not mandatory for the president to follow this process, the court said that doing so is wise and helpful, and the Supreme Court's opinion, even if not bounding, it holds a strong persuasive value, and this would help prevent unconstitutional laws, save public resources, and reduce legal challenges later. And the court said that only constitutional courts, not the executive ones, should assess the legal validity of a bill. And since governors have no directive way to consult the judiciary, the only route is through the president, who can use Article 143. And the judgment cited practices in the Sri Lanka and Kiribati, where similar constitutional rules exist, and it also referred to the Sarkaria commissions, and uh, uh, the recommendation of this commission is that the president should consult the Supreme Court under Article 143 when a bill may be unconstitutional. And however, the Supreme Court added that it would not give opinions on purely political or policy related matters, following the political thicket doctrine, meaning that the court should not interfere in areas reserved for the executive. That's all from my side.
This article talks about the yet another aspect or facet of the Supreme Court ruling, in which they have given a time frame within which um, the governor or the speakers have to act. The another aspect of the ruling is that the Supreme Court must be consulted in all those matters where the governor reserves the matters for the presidential consideration on the ground of infringement of some law or infringement of the constitution. Then in that case, the governor is required to um, required under the constitution to reserve the bill for consideration of the president if there is a likelihood of a central law getting infringed or a constitutional provision getting infringed or the powers of the high court getting infringed. In all these cases, the governor shall reserve the bill for consideration of the president. Acting on past commissions, recommendations made by past commissions such as the Sarkaria Commission, the apex court has implemented those recommendations of the commission by stating that laying it down as a matter of policy for the president to follow, and but not making it mandatory, but making it the president has the power. Nobody else has the power, but only the president has the power. And this is given in Article 143. I'll share it once again. I've been able to share it once again. The power has returned, but then the disruption was caused. So that time it appears to the president that a question of law has arisen. So it is the discretion of the president. All right. It is not the discretion of the governor. One of the questions the governor was given. It is the discretion of the president and president only. President means central government, because we follow we are a republic where the president is indirectly elected, head of the state is indirectly elected. Therefore, it is the government which is directly elected, which gives the advice to the president, and the president acts in that advice. All actions are taken in the name of the president of India, but actually they are actions of the central government, according to conventions of parliamentary democracy. So this is the president that question of law. So what can be referred to the Supreme Court? Either a question of law or a question of fact. All right. Either a question of law or a question of fact. Anyone may be referred. Is likely to arise, which has already arisen or is likely to arise. So it may arise in, say, it is likely to arise in, it is foreseeable that it is likely to arise. So this can be this kind of reference, which is of such a nature and such public importance that it is expedient to obtain the opinion of the Supreme Court upon it. So such a nature and expediency that opinion of the Supreme Court should be taken upon it, then the President may make an advice. Then what the Supreme Court has to do? He may refer the question to the court for consideration. Now, what court has to do is here. Court may, after such hearing as it thinks fit, report to the President its opinion thereon. So what is being written here is court may. That means it is not mandatory on the court to give an opinion merely because the government or the President tells the court that please give us an opinion on this. The court is not bound to give an opinion. The court will say that we will not say anything on this because this takes us in the political cricket or this takes us into policy matters. The courts are at liberty to say so. And it also says that Parliament, notwithstanding anything in the proviso to Article 131, refer a dispute of the kind mentioned in the said proviso. So when there is a central state dispute, or there is a dispute between several states on the one side and the central government on the other side, or there is a dispute between several state governments, then in that case also the President may refer that question to the Supreme Court for its advice, either on a statement of fact or on a question of law, or on a question on which the right of the party depends. That is how Article 131 is framed. So I'll just share Article 131 also. So he says, subject to the provisions, the Supreme Court shall, to the exclusion of any other court, have original jurisdiction. So this is a matter of original jurisdiction between the Government of India and one or more states, Government of India and any states on the one side and one or more states on the other, between one or more states, if and insofar as the disputes involves any question of law or fact on which the existence of a legal right depends. Existence or extent of a legal right depends. So on a legal right, on a fact, or on a question of law. On these three things, the presidential opinion may be obtained. That it may be something like center-state dispute under Article 131. Now, when the governor withholds the bill for consideration of the president, it is actually a center-state dispute only, right? Because then the state legislature is being accused of trampling upon the powers of either the High Court or a prior central law or the Constitution of India, right? So this, then secondly, the Supreme Court is not bound to give its opinion. If it thinks that it's a matter of policy, it may return the reference which has been made to it, and it may say that look, we are not going to give our opinion on this because, for example, in the Ayodhya Babri Masjid case, the president had referred the opinion, had referred the question to the Supreme Court for their opinion on whether on the disputed site the temple existed or a mosque existed. So they made that kind of reference. Then the Supreme Court said that, look, we are not going to decide on this reference because either way we decide, then we will end up annoying the other community. And we will have to play. This is not the kind of question we are going to entertain in the presidential reference. And they returned the reference stating that this plays one community against the other. This pits one community against the other, and therefore we are not going to give our opinion on this. The Supreme Court has refused to give its opinion. Refusal to give its opinion is not a reflection on the wisdom of the president, mind you. It's just an official action, that's all. Nobody is saying that, look, the president, how foolish he is, what kind of question he is referring. No, that is not the point. That is not done. Wisdom of the president is not called into question. It is just that it is found that the question which has been referred may not be appropriate or proper for the Supreme Court to entertain such a question. That's all there is. Now let us go to the questions. Let us take up the questions, and the questions are here on our screen. Question number 87. I think most of the questions are correct. Question number 7. No, it is 700%. It is 8. Parliament enacts a law that is later struck down by the Supreme Court as unconstitutional. Critics argue that the president should have sought the opinion earlier. What justification is most aligned with the Supreme Court's advisory opinion on 143? Seeking prior opinion could have saved the public resources and legal. Why did you make this mistake? This is a very elementary question. Laws passed by the parliament are always immune from judicial review. Yeah. Then 89. A union minister publicly announces that a bill reserved by a governor is clearly unconstitutional and must not be assented to. The Supreme Court's view on such action would most likely be the minister is free to comment, the union executive ought to defer to constitution. This is the same question in the other way around. Right? So I need not dwell too much on it. In a state, why the governor doubts that is what I was talking about. If the governor does not have the power to refer a bill to the Supreme Court for advice, it's only the president who has the power. Governor doubts the constitutionality of bill and writes to the Supreme Court asking for opinion. No, you can't do that. Governor must reserve the bill for the president only, and the president will decide whether or not to refer. So the president refers a question to the Supreme Court under 143 regarding whether a new agricultural subsidy policy. Now the matters of policy is not there, so you should not have decline to give its opinion would be the correct option because it's a matter of policy. Supreme Court does not go into matters of policy. All right. That finishes this job. It's already 4 o'clock, so we will not prolong this session further. Tomorrow we will take up the logical reasoning part of this paper. And tomorrow, please also prepare the legal reasoning part of the next paper because we will go a little faster now. We are now slightly comfortable in the sense that now we know how to handle the questions on logical reasoning. Students are coming to grasp with something like the difference between an opinion and a factual proposition, and that is the most important. Whether the author is likely to agree with it, whether the author is likely to disagree with it. If the author's argument is this, then what would be a necessary conclusion? Therefore, in one way or the other, everything is centering around the author's argument. Therefore, if we have correctly picked up the author's argument from the factual mess which has been the mess, but factual, the world of facts which has been forwarded to us, then in that case, our job to that extent becomes easy. Once the argument is clearly identified, once the drift of the argument is becomes a problem when you don't draw the distinction between facts and legal facts and propositions of principle, then it becomes a problem. If you find it difficult to see which is the argument actually, as distinguished from the facts which are used in order to strengthen or weaken or argue one side or argue the other side, then it becomes slightly problematic. Otherwise, should not be a problem issue at all. So having said that, kids, let us meet tomorrow at the same time with the logical reasoning. Please go through legal reasoning of mock 68 also, because probably tomorrow we will be taking up the logical reasoning of this and the legal reasoning of 68, and if time permits, then logical reasoning of 68 also tomorrow itself, right? Okay, beta, bye-bye.
Dear students, GPS CLAT Academy at Gyanodaya, a senior secondary school at Sikar, supports its students in their CLAT preparation. We have started a lecture series which will be delivered to you on a daily basis on YouTube. The lecture series revolves around discussion of mock papers. You can request us for the concerned mock papers. If you intend to join us in our daily discussions, you are most welcome.